but the arrests they made under state law, they cannot make. So what this case is about something called independent state grounds. And you need to write this down. You need to write this down. What is independent state ground? Independent state grounds are if the federal Constitution allows the police to do it, the federal Constitution says the police can make an arrest based on probable cause in this specific instance. So the police make an arrest based on based on probable cause, which doesn't violate the Fourth Amendment. The state didn't say that the arrests they made violate state law. So the state can say the arrest the police made violates state law, even though the arrest does not violate the federal Constitution. That's called independent state grounds. So the states, because they're sovereign entities, can give citizens of their states more rights than what the federal Constitution gives them. State constitutions and state laws can give people in that state more rights than what the federal Constitution provides. Okay? That is independent state right. So in this case, police were on patrol and they heard the police radio say that Moore was driving his car. The police knew, this specific officer knew Moore had a suspended license. So his car was stopped. When his car was stopped, they didn't find out that Moore had a suspended license. So they arrested Moore on the misdemeanor charge of driving on a suspended license, which is punishable under Virginia law by a year in jail and a $2,500 fine. That seems like a lot of punishment for a suspended license. But anyway, that's the Virginia law. So after arresting Moore, they searched him, and then they found crack, cocaine, and some cash, $500, $560. And when you arrest somebody legally, it's something called search incident to an arrest. So if you arrest somebody legally, you can search them. Search incident to an arrest. So he was arrested for driving on a suspended license, a proper arrest, then he was searched incident to that arrest, and they found a crack, a large sum of cash. And when you find 60 grams of crack and $560 in cash, you can make a reasonable inference that he's selling crack. So Moore were charged with possession of cocaine with the intent to distribute. So when you're charged possession of drugs with the intent to distribute, that means you're a drug dealer. Or you're charged to be a drug dealer. That's what the state thinks. So Moore filed a motion to suppress, which, as we know, when you file a motion to suppress, you're trying to get the evidence the police wants to use against you thrown out. And the motion to suppress is always a pre-trial motion. It occurs before the trial. Because you have several hearings before a judge before the trial. Like, you'll first have a hearing to determine, was the arrest based on probable cause? Yes. That may be what they call the initial appearance. And then you will have an arraignment where you'll try to get the motion, or you'll try to get the evidence the police have suppressed or thrown out, saying it was a bad search. But the trial court denied the motion to suppress, which means the evidence can be used against him. The evidence will not be suppressed. So the evidence the government has can be used against Moore in trial. So Moore had a bench trial, meaning it was just a judge and no jury. He was found guilty and sentenced 5 years in prison with only a year and 6 months of the sentence suspended. So what does that mean? He's really only going to serve 3.5 years. So the Court of Appeals of Virginia reversed the trial court and said he should not have been found guilty. And the Supreme Court of Virginia reversed the Virginia Court of Appeals. And they said, since the arresting officers should have issued more citation under state law, and the Fourth Amendment does not permit search incident to a citation, the arrest violated the Fourth Amendment. And then it goes to the Supreme Court. Just the Supreme Court grants certiorari. That means they take the case. When they grant certiorari, that's the rule of four. Four justices want to hear the case. The rule of four. So they say, we'll take it. Because the Supreme Court has discretionary review of their doctrine. What does that mean? They get to decide what cases they hear. Thousands of people want the Supreme Court to hear their case. They only take about 60 to 70 cases every year. So their docket means the cases they're going to hear, is discretionary. They get to decide. So if there's 9 justices on the Supreme Court, so if 4 of them say, we want to hear the case, then we hear the case. But you need at least 5 justices to win. So Justice Scalia writes the opinion. So he says, in order to see if the Fourth Amendment was violated in this case, you have to go back to the history of the Fourth Amendment. So you have to go back to common law. We come from English common law. So what's the common law tradition? And he says the history informs that the courts and the law will tell you what the law was at the founding of the country. So Justice Scalia was a conservative, so he likes to go back. Conservatives like to go back and look at the history of common law, and that history should be repeated today. Conservatives want that original, they're called originalists. Conservatives are originalists, meaning when they interpret the Constitution, they think how the original founding fathers wrote the Constitution should be the way we interpret the Constitution today. That's why they're called originalists. What was the original meaning of the Fourth Amendment? How was it used? And he says there was no historical evidence to show that the Fourth Amendment was limited activity in this situation, that Moore could not be arrested for driving on a suspended license like that. There's no evidence that he could not be arrested, which means he could be arrested. So the framers, when they talk about the framers, that's the people, the original people who wrote the Constitution and the Fourth Amendment, said that the Fourth Amendment prohibits warrants and writs of assistance by English judges. That the English colonizers would arrest our colonists before we became country who writs of assistance, meaning they made things crimes, and you didn't know it was a crime. They just made it up, and they arrested you for anything or nothing. And there was an early Supreme Court Justice Joseph Story, said that the Fourth Amendment affirms the great constitutional doctrine of common law. And the Fourth Amendment common law was not intended to incorporate subsequent statutes. So that what they're saying is that the Fourth Amendment doesn't limit what the police did. The early Congresses tied the arrest of authority of federal officers to state laws of arrest. Searches and incidental warrantless arrests were taken for granted at the founding. The founding means the original, what the original meaning of the Constitution was, written by the framers or the fathers of the Constitution. So Moore has no historical argument that the evidence should be suppressed based on the Fourth Amendment. Fourth Amendment says that the evidence here should not be suppressed. It should go in against him, trial. So then he talks about the Fourth Amendment is based on reasonable. Search and seizures have to be reasonable. And so you need to conduct a balancing test of interests. So, on a scale of justice, on one hand, you got the privacy rights of the individual. On the other hand, you have the interests of the government. And you balance the interests of the government, whatever the government did, searching for incident to arrest, stopping him on a suspended license. He has some privacy rights. The government has rights too that you want to protect the public from people from driving on a suspended license, because presumably if Moore has a suspended license, he shouldn't be driving. So you balance those two interests, the interest of the government and public safety versus the interest of Moore and privacy. Who wins the balance? And Justice Scalia says, when the police have probable cause that somebody has committed even a minor crime, arresting somebody for a suspended license is not a huge crime. It's not an armed robbery, it's not a homicide, kidnapping. So when you're arrested with probable cause of a minor crime, the balancing test falls in the favor of the government. So under the Fourth Amendment, the arrest is constitutional. Okay, and then he talks about this case, California versus Greenwood. In that case, the California Constitution said you could not search based on California law, not federal constitution. The California Constitution said you could not search an individual's garbage. And they enshrined that into state law. The California, when you take every Tuesday, I take my garbage out to the curb with those big garbage bins. In California, they have a law that says police can't search that garbage in California. But under federal law, under the Fourth Amendment to the Constitution, that's federal law, the Supreme Court has said that police can search the garbage and it doesn't violate the Fourth Amendment. Once you take your garbage to the curb under the Fourth Amendment, you've abandoned your privacy rights. When your garbage pail is like right next to your house or in the fence around your house, you still have a little privacy in that garbage. But once you take it to the curb for the trash people to pick up, you've abandoned your Fourth Amendment rights. So the police or the government can go through your garbage and it doesn't violate the Fourth Amendment. However, in California, if the police go through your garbage, it may not violate the Fourth Amendment to the U.S. Constitution, but it doesn't violate California law. So you have more privacy under California law than you do under the Fourth Amendment. This is independent state grounds. Independent state grounds gives people more privacy rights under the state constitution or state laws, more privacy rights given to people in the state where the Fourth Amendment doesn't give them those privacy rights. Yeah.
So if California law prevents law enforcement from looking at it, but the Supreme Court says that it just means that California can pass their own laws on it, or does it mean that California is violating case law?
No, because we have dual sovereignty.
Mm.
California is a sovereign entity. So California can pass laws that apply to California citizens. Federal government is also a sovereign entity. They provide federal constitutional protections under federal law. If you don't have privacy under federal law with your garbage on the curb, that doesn't violate the Fourth Amendment. But California says it does violate our state law.
Okay.
So you have more privacy with your garbage on the curb under California law than you do under the federal constitution, the Fourth Amendment.
I see the difference.
So what California cannot do is give people fewer rights. If the Supreme Court says, and this is not the law, but as per an example, if the Supreme Court says the garbage on your curb is protected by the Fourth Amendment, and California law says that the garbage on your curb violates California law, that cannot be done by the California, because the Fourth Amendment trumps the California law in terms of if the Fourth Amendment gives you that privacy, the California Constitution can't come in and say you don't have those privacy rights. But what California can do is give you more privacy than the feds.
Makes sense.
Not less. So Virginia protects in this case, Virginia has a law that protects more privacy than what the federal Constitution protects under the Fourth Amendment. The Supreme Court deal with the federal Constitution, federal laws. Virginia can have a privacy law based on Virginia law that gives more protections than what the Fourth Amendment does. So states are free to regulate arrest any way they want to. This is based on state law. But Justice Scalia is saying, regardless of what the state law says, we being the U.S. Supreme Court, we interpret what the Fourth Amendment is. So Justice Scalia is saying, if you arrest for probable cause, that's lawful under the Fourth Amendment. And a search incident to the arrest is also lawful under the Fourth Amendment under the federal law. So after officers arrest somebody, they can search. They don't need anything further. They don't need any other evidence to justify their search because of this doctrine, search incident to a lawful arrest. So what happened to Moore is his evidence was thrown out because the state of Virginia provided him more privacy rights than what the Supreme Court said the federal Constitution gives you under the Fourth Amendment. So this is why I said this is independent state grounds. States can give people more rights than what the federal Constitution gives you. So you understand that concept, right? So there was a case a few years ago about sobriety checkpoints. I mentioned sobriety checkpoints, right? Or I think sobriety checkpoints are, where the police can set up roadblocks on the highway, stop everybody, even if they have no suspicion at all you've done anything wrong, and check your sobriety. Or they can stop every 10th car or every 20th car, because if you're on 45, let's say if you stop every car, you'd be there forever, right? That would be too long of a detention. The whole idea was sobriety checkpoints are constitutional under the Fourth Amendment, so that it's a brief stop. You roll up, you drive up, you roll down the window, the cop smells your breath or has an alcohol sensor or a flashlight, determines you're either got alcohol on you, on your body, or your breath, or not. If you don't, they have to let you go. So it's just a brief intrusion upon your rights. And the court said, well, because drunk driving is such a horrible problem, we're going to allow that to occur under the Fourth Amendment. But you don't have privacy under the Fourth Amendment to be free from a sobriety check. Minnesota, however, passed a law based on Minnesota's constitution that said police cannot conduct sobriety checkpoints in Minnesota because Minnesota citizens, based on independent state grounds, this has nothing to do with the Fourth Amendment. We're ruling totally on some kind of privacy right in the Minnesota Constitution. The Minnesota Constitution gives you privacy to be free from a sobriety checkpoint. That's independent state grounds. So, if you're worried, if you're a state, you're worried about the Supreme Court taking away your privacy rights, in a bunch of areas, then based on your own state constitution, you can give citizens more rights. Now, this is very plainly seen after the Supreme Court overturned Roe v. Wade and said there is no more constitutional right to abortion. Because Roe v. Wade is a federal constitutional case. The Supreme Court said in 1973, women have a right to an abortion based on the federal constitution. It's a federally guaranteed right. Well, a couple of years ago, based on that Mississippi law, the Supreme Court said there is no more federal guarantee to abortion under federal law. So what's happened since then? several states have enacted laws based on independent state grounds that say, well, Texas is not one of them, but in Missouri voted in the 2024 election. The citizens of Missouri voted saying women do have the right to abortion in Missouri, which means under Missouri's constitution, based on independent state grounds, Missouri gives women more privacy. It's called bodily integrity. You have more privacy under the Missouri Constitution to have an abortion, and your privacy rights that you get is from the Missouri Constitution, not from the federal Constitution. So Missouri is giving women more rights, the right to an abortion, than what the federal Constitution gives each of them. Now, there's several states that have done that. I can't tell you all the states. I think abortion's legal in New Mexico. It's legal in California. It's legal in New York. There's a handful of states around the country where abortion is legal. And all those are based on, not on a federal guaranteed right to abortion, but on state law rights to abortion within that state. So President Trump appointed the justices to the Supreme Court that overturned Roe v. Wade. And so President Trump, being a good politician, said there is no federally guaranteed right to abortion for the whole country. However, based on independent state grounds, states can give women that right to abortion. It doesn't exist federally. So that's what's going on now. So some states have what they call referendums. So they'll put like the question on the ballot. That's what Missouri did at the 2024 election. There was a vote on the ballot when you went to vote for president. There was a question on there that said, under the Missouri Constitution, you want to enshrine the right to abortion in Missouri, and that passed. So this whole idea of independent state grounds is interesting because the states can give you more rights than the feds. Now, the people who supported Roe v. Wade, which gave everybody in the country under the federal constitution the right to abortion, said, well, it's unequal that in Texas you do not have a right to abortion, but in New Mexico you do. In New York you have a right to abortion, but in Florida you don't. So it's a patchwork of, kind of here and there. But because we have dual sovereignty, and each state is a sovereign entity based on their own constitution, based on their own laws, each state can do whatever it wants to, as long as it doesn't violate the federal constitution. Each state can give people more rights than what the federal constitution guarantees, and that's independent state ground. And that's what's going on here. And that's what's going on in Minnesota with the sobriety checkpoints. And now you see it with abortion. I think those are the best examples.